Good afternoon. My name is Paul DeBolt. I'm the chair of Venable's Government Contracts Group. On behalf of BDO and Venable, I wanted to welcome you to our fourth and final webinar relating to issues and challenges that government contractors are facing during the COVID-19 pandemic. Today's webinar is entitled CARES Act, It Ain't Money for Nothing, A Government Contractor's Guide to Mandatory Disclosure. Joining me on the panel today are Derek Shaw, Managing Director in the Government Contracts Group at BDO, and Spencer Williams, one of my colleagues in the Government Contracts Group here at Venable. The three of us really appreciate you taking time out of your day to join us, and we hope that you find the webinar informative. So we have a couple of objectives today. One of the main objectives is to ensure that everybody on the call has a working knowledge of the fundamental principles of the mandatory disclosure rule, an understanding of the federal government's expectations for contractor cooperation, and takeaways for avoiding suspension and debarment for failing to disclose fraud, conflicts of interest, bribery, or other gratuity violations. The first thing we're going to do, though, we're going to move to our first polling question. And the first polling question is, has your company ever submitted a mandatory disclosure? And we'll give the audience about 10 seconds rather to answer that, and we'll see what the results are showing. So what do you guys think? 50-50, 60-30, Derek, Spencer?
I'm not sure what the over-under is, but I'm going to go with no.
Going to go with no, okay. What about you, Spencer?
Yeah, I feel like it'd be no. You're going to go with yes, Paul?
The survey says, what's that?
Well, there you go.
The survey says no. Only 37% of the people on the phone their companies have submitted a mandatory disclosure. So that's it's kind of interesting because the whole history behind the mandatory disclosure provision was when it used to be voluntary disclosure, the government didn't think that contractors were being honest enough, and so they made it mandatory. But it seems like a lot of companies are doing a really good job of staying out of trouble, which is really is excellent. Spencer, I was going to turn it over to you, and maybe you could walk us through some of the pre-COVID-19 developments and some of the other issues relating to the background of our presentation today.
Yeah. Thanks, Paul. Hi, everyone. So my name's Spencer. Nice to meet you all. So I'm just going to give you a little background on kind of why it's important during these times to be familiar with the mandatory disclosure rule. So pre-pandemic, the government had already signaled a renewed interest in investigating and prosecuting instances of procurement fraud. As you see here, late last year, DOJ announced the formation of a task force. This task force purpose is to deter, investigate, and prosecute antitrust crimes such as bid rigging conspiracies and other fraudulent schemes that could undermine competition in government procurement, grants, and program funding. Earlier this year, DOJ announced that it had recovered over $3 billion from False Claims Act cases for fiscal year 2019. Behind healthcare fraud, procurement fraud recoveries constituted the second largest category of FCA recoveries. Lastly here, you see Department of Defense's OIG announced that it had received 180 contractor disclosures, the majority of which concerned labor mischarging. Go on to the next slide. Now, with COVID-19, in the wake of federal response to the current pandemic, Congress has passed a number of stimulus packages to assist and to keep the economy afloat. At over $2 trillion, the CARES Act, which was signed into law on March 27th, is one of the largest and includes a number of provisions relevant to government contractors. The most important of which is Section 3610, which authorizes reimbursement for contractor costs to maintain a ready status during quarantine. Importantly, for our purposes today, Section 3610 also requires that a reduction in that reimbursement if the contractor receives relief under another provision. meaning we can expect auditors to be looking for such instances in the years to come. Additionally, the DOJ has set up a hotline for reporting COVID-19 fraud and has directed U.S. attorneys to prioritize the investigation and prosecution of COVID-19 fraud. All right. Now, while the pandemic has harmed many and presented some unique challenges for everyone, if we look at previous incidents of major disasters and the government's response, you see a pattern that after dishing out large amounts of money, the government will go back to make sure that money was dished out correctly and used for the purposes, the intended purposes. For example, in the years following the financial crisis, included in the Troubled Asset Relief Program, Congress created a special Office of Inspector General. This OIG worked with the DOJ to investigate financial crimes, fraud, and abuse related to the TARP program, which resulted in a number of FCA enforcement actions. And that OIG still operates today. In a recent quarterly report to Congress, they reported that its investigations had recovered approximately $11 billion and resulted in 381 convictions, which is a 96% conviction rate. Following Hurricane Katrina in 2005, the government investigated and prosecuted a number of alleged FCA violations. In one instance, Contractor built a base camp to house and feed first responders, made false statements in submitting invoices, and failed to build the contracted for number of housing. Litigation for that lasted about 3 years. They included discovery, motions practice, and settlement discussions, and ultimately ended in a $5.3 million judgment. And the contractor also had to, pay for those attorney fees for those 3 years of litigation. Lastly here, the war on terror the Afghanistan and Iraq wars. That's the origin of the mandatory disclosure rule. DOJ and Congress were outraged and embarrassed by a number of headlines showing allegations of contractor fraud relating to these wars. At DOJ's request and following congressional action, the FAR Council promulgated the mandatory disclosure rule. And for a discussion of that rule, I'll turn it over to Derek with a video.
Thanks, Spencer, and good afternoon, everybody. So what is the mandatory disclosure rule, and why are we here today, right? So fundamentally, it's a regulation that requires contractors to self-disclose credible evidence of certain violations of law and significant overpayments in connection with federal contracts or subcontracts. Excuse me. So it's a disclosure to the cognizant agency inspector general, by the way. The rule sets forth some requirements that you see on the slide here. So it requires mandatory disclosure of criminal violations involving fraud, conflicts of interest, bribery, gratuities under Title 18, disclosure of Civil False Claims Act violations, and disclosure of significant overpayments from the government. And we'll get into what that means in a little while. So as Spencer says, the rule was published by the FAR Council back in 2008. If you go back in time a little bit from there, for a little more historical context, prior to that, as Spencer was saying, DOJ had expressed some frustration with the Department of Defense contractors who weren't really keeping up with other industries in terms of self-governance. And that gets into the stuff Spencer was talking about, particularly, shenanigans in the war zone in Iraq and Afghanistan. So think about some of the self-governance requirements and processes in industries like banking and securities and healthcare and things like that. And there weren't really similar self-governance programs for DoD contractors, other than what was already in the FAR. So, you can argue if that was a fair assessment or not, but that was DOG's opinion at the time, and that's what essentially led to the rule. So the rule also requires establishment of a couple of compliance programs that you see on the slide here at FAR 52203. We'll talk about those in more detail in a little while. But at a high level, 52203-13B requires contractors to have a written code of ethics and develop internal procedures to detect, process, investigate, and assess potential violations to determine whether there's credible evidence triggering a reporting obligation. So to see if it meets one of those criteria up above there. And then 52-203-13C requires establishment of a business ethics awareness and compliance program and internal control system within 90 days of a contract award. So these are contract clauses. So technically the rule applies to contracts and not contractors necessarily, kind of like cost accounting standards do. But in practical application, it really spans the entire business. So as I said, the clause applies to covered contracts as a mandatory clause. So what's a covered contract? Well, it's a contract or a subcontract issued on or after December 12th, 2008. So that's when the rule came into play. That have a value of $5.5 million or greater, period of performance of greater than 120 days. That $5.5 million value, by the way, includes option years, so it's not just the base award for the contract. There's a couple of exemptions. As with a lot of regulations, it doesn't apply to small business concerns or to contracts for acquisition of commercial items. Although, as we'll talk about as we go along here in the presentation, even if your business is technically exempt from the rule, it's really best practice to have these same programs and controls in place anyway. As I said, 52-203-13 is a mandatory clause for covered prime contracts. Additionally, the substance must be inserted in any covered subcontract issued under that prime contract. So as with the prime awards, a covered subcontract is also a value of $5.5 million or greater, including options, period of performance greater than 120 days. And since it's a mandatory flow down in covered subcontracts, subcontractors are also then required to include it in any covered lower tier subcontract, so it can flow all the way through. I should also note that the FAR requirements here have some tentacles beyond just the mandatory disclosure situations. So those FAR 52-203-13 clauses for code of conduct and ethics compliance programs have also made their way into requirements for an adequate accounting system, which you find in the DFARs at 252-242-706, which is the accounting system administration clauses. Also, the accounting system narrative questionnaire that's used by DCAA in reviewing your accounting system explicitly requires contractors to discuss ethics and compliance program, codes of conduct, hotline posters, employee training in these areas, and explain the communication of integrity and ethical values. So in addition to that, the control environment section in the accounting system also includes codes of conduct, self-governance, ethics training. So if you have flexibly priced contracts and you're required to have and maintain an adequate accounting system, these are important processes and controls, beyond the mandatory disclosure requirements. And again, that gets back to best practice of having these things in place, even if you don't necessarily have the clauses in your contracts.
Yep. Derek, before you jump to the next slide, I think it's important to remind everybody on the call today that, it's not enough simply to have these requirements on a shelf in a book. You actually have to use them, follow them, train your people on them, so that if something does happen and you need to make a disclosure to the government, that the government's going to believe that you've created an active culture of compliance. If you don't provide the training, you don't provide annual updates, you don't make employees certify that they've received the training, that they're going to report any irregularities, there's a real risk that the government's not going to take you seriously and not find that you've established a culture of compliance, which is what you're going to need as part of the mandatory disclosure process.
Yep, exactly. You gotta walk the walk, is in addition to talking the talk there. So if I'm a contractor and I have a reportable issue and I don't disclose it, what are the risks? Well, suspension and debarment is a risk. Contractor can be suspended or debarred for a knowing failure by a principal to timely disclose to the government in connection with the award, performance, or closeout of a government contract or subcontract. And credible evidence, as I said up front, that's violation of criminal law, fraud, conflict of interest, bribery, violation of Civil False Claims Act, or a significant overpayment. And we'll get into what an overpayment means here in a second. So on this slide, there's a couple of terms we need to deal with here. Some of these aren't very well defined, frankly, which I think led to a lot of confusion in the industry in the early days of the rule. Paul, I don't know if you saw this too, but contractors weren't really sure what to disclose or when to disclose. There was a lot of inconsistency. So I think you had a lot of contractors sort of flooding the zone, over disclosing, and some maybe go in the other direction and not disclosing when they should. But there's a lot of inconsistency early on in the rule, I think.
Yeah, I think it's taken a while to establish what the rules of the road are with the IG. I mean, I remember, some of the larger companies, they would basically just take an Excel spreadsheet and every quarter just do a dump to the IG and say, well, here's everything that happened. We're not saying whether it's good, bad, or indifferent. It's just some stuff happened and we thought you might want to know, which I don't think is what the rule is getting at.
Yeah, so I think it all finally settled into a rhythm there. But yeah, up front, you're right. I mean, I saw contractors, every labor charging issue, which you would normally just fix, became part of a disclosure. And whether that was just to, like I say, to sort of flood the zone and say, okay, you want my disclosures? Here's my disclosures. Or if it was just an overabundance of caution, I'm not sure, but I think it's settled down since then. So anyway, in this case, a principal means an officer, director, owner, partner, or a person having primary management or supervisory responsibilities within a business entity. That definition can be interpreted broadly, so it could include compliance directors and officers, directors of internal audit, other positions of responsibility, that might have knowledge of reportable incidents or controls around them. So that can be pretty broad. But a principal is actually one of the few terms associated with the rule that's actually defined by the FAR in this case. So then what does credible evidence mean? Well, the FAR does not define credible evidence. But if you look in the preamble to the mandatory disclosure rule, it gives you some clues there. It notes that the contractor should have the opportunity to take some time for the preliminary examination of the evidence to determine its credibility before deciding to disclose to the government. So that's a little guidance from the FAR, but not an actual definition. However, credible information, not credible evidence, but credible information is defined in DFARS at 252, 246, 703. And in there it says that information that considering its source and the surrounding circumstances supports a reasonable belief that an event has occurred or will occur. So it's really kind of those, I know it when I see it kind of things. But as the rule states, you do have an opportunity to do an internal investigation and make a determination of whether or not there's credible evidence, however you may define that, that would lead to a disclosure. So it's also best, by the way, to work with legal counsel to make that determination. And that leads us to significant overpayment. So guess what the definition of significant overpayment is? If you guess there is none, you'd be correct, but we should have made that a polling question, Paul. So the rule fails to define what a significant overpayment is, but it does exclude certain types of payments, specifically advance payments, performance payments, commercial advance interim payments, prog pays, normal interim payments under cost reimbursable contracts. So the aim here, again, is not to require disclosure of every single, simple billing error that might occur, and those are things you might just correct in the next billing cycle. So those are things you typically catch. You communicate those and coordinate those with your ACO. You correct it in the next cycle, as opposed to an actual fraudulent claim that would require disclosure for an actual significant overpayment.
Have you seen, in your communications with the government, have you seen any guidance on what constitutes a significant overpayment? Sometimes when I'm dealing with a government representative, you almost get the impression that if they think it's a lot of money, then it's a significant overpayment, irrespective of what the overall contractual value is or the context. It's almost as if you had a $12 billion contract and you had $100,000 overbilling, that because I think $100,000 is a lot of money, then it's significant overbilling.
Yeah, seems to be completely subjective. I think you're right. It's hey, that sounds like a lot of money to me. It must be significant. I've not seen anybody put a boundary around it as in terms of percentage of a contract or any kind of dollar threshold. It seems to be completely subjective, which of course leads to confusion among the contracting base. When is it significant? There's no real good definition. So then when do you need to disclose? Well, you have to make a timely disclosure, and guess what? There's no definition for that either. However, in the preamble to the final rule, again, there's some guidance where it says that until the contractor has determined the evidence to be credible, there can be no knowing failure to timely disclose. So again, the rule allows contractors the opportunity to do some preliminary examination of the evidence to determine its credibility before deciding whether you need to disclose to the government. But you would be well advised that it should not take longer than necessary. So don't sit on this stuff, right? So it's not looked upon favorably should you end up having to make a disclosure and they determine that it was not timely. A couple things on the slide here on the last couple of bullets there. You see the timely requirement should be read in the context of credible evidence standard, which provides, again, for a period of internal investigation to determine whether evidence is credible before it's disclosed. You should take reasonable steps to determine evidence is credible and not launch like some big, giant, complex investigation right off the bat. You need to make some kind of determination whether it's credible or not. Again, no time frame for what constitutes reasonable investigation. Disclosure requirements under the clause apply prospectively from December 12th of 2008. Again, that's when the rule came into play. But examination of past conduct on contracts open to disclosure is still required. So there may be some look back required there as well.
Yeah, Derek, I mean, I know a couple instances where we've had clients that it appeared there was a pretty serious problem and the investigation was going to take some time because of the logistics of getting people together, or there were people that were overseas that we needed to talk to. So I mean, occasionally you almost have to do a two-part disclosure. I don't know if you have done that as well, where you go in initially just to put a line in the sand to let the government know that there could potentially be a problem and that you are investigating it, and we'll let them know. But sometimes, given the gravity of the problem, it makes sense to maybe go in a little bit early to ensure you don't get second guessed on the timing of the disclosure. I don't know if you've run into that or not.
I have, yeah, especially like you say, when you have logistics that get in the way, and the investigation is going to take longer than maybe you think. So yeah, it's good to make that initial disclosure. Let them know, hey, more, here's the initial determination, more to come, investigation is ongoing. But you don't want it to drag out so that they come back to you and say, hey, you did not disclose timely. At least you can say, look, it's not that I didn't tell you. I gave you an upfront warning. So yeah, I've seen that too. So what do companies have to do? Well, you need to make sure everybody cooperates with all government agencies responsible for audits, investigations, and corrective actions. It's not at all helpful to be perceived as not cooperating. That should be a no-brainer, but companies' employees do sometimes get defensive. So just ensure that everybody involved understands their responsibility to be cooperative. What the rule does not require is for the contractor to waive attorney-client privilege or work protections. It doesn't require an officer, director, or an employee to waive attorney-client privilege or to waive Fifth Amendment rights. As an aside on this item, in my prior life before coming to BDO, I spent my career in industry. And one of the things I did in industry was, supporting internal investigations of these types around mandatory disclosures. So occasionally when I'd be interviewing employees about the potential issues, once in a while I would have one of them tell me that they weren't going to answer my questions on Fifth Amendment grounds. So I had to remind them that they had a Fifth Amendment protection from the government, but I'm not the government. I'm the employer. So you do not have a Fifth Amendment protection from me. So sometimes an employer has some additional leverage there that the government actually doesn't have. Anyway, on that topic, though, so the rule does not refrain the contractor from conducting an internal investigation. Again, as we talked about, you need to investigate in some form to determine if you have a disclosable event or if you don't. So as we saw on the rule overview slide, under FAR 52-203-13, contractors performing covered contracts are required to have a written code of business ethics and conduct. That seems like a simple enough requirement. Of course, the first thing is the contractor should ensure that their codes are in writing, as is required. Second, contractors should have a uniform method for distributing that code to employees. Technically, that means all employees engaged in performance of the covered contract, either directly or indirectly. But best practice is obviously to treat all employees equally here and make it available to all employees in case you need it. So while the code is only required if you have covered contracts by the final rule, it's best practice for all government contractors to have one in place. And that gets to the last bullet on the slide here, as Paul was talking about earlier, on the code of conduct that otherwise promotes an organizational culture that encourages ethical conduct and a commitment to compliance with the law. So it reflects that internal reporting is important because it's the right thing to do. It's in line with the culture of the company. So that's that culture of compliance that we talked about. So Spencer's going to talk a little bit more about this when he talks about internal controls. But the code should really clearly articulate steps for an employee to take if they suspect there's a violation. So let them know which individuals within the company they can report that to. Some companies, have an internal compliance officer designated to get those reports. Some companies direct people to go to legal or to HR. But the code should be clear about that, and employees should understand, where the reporting chain is. So you do have flexibility in how you distribute the policy. It's not prescriptive about that. You can use electronic delivery, a web link, that's fine. But the key is training people so they know it exists and they know where to find it. So periodic training is a good practice. Some companies, especially larger contractors, have an annual certification, as Paul mentioned, that they make employees acknowledge. And that can come in handy if you find yourself in a disclosure situation, because then you can demonstrate that you do periodic training. Every employee is acknowledged that they're aware of the policy. So that acknowledgement that they've read the code, understand it, and intend to comply with it can be important. So I think that's going to move it to Spencer to get into the controls programs. Right?
Yep. Thanks, Derek. All right. So yeah, if you look at the slide, you'll see here's some requirements for your contractors to include in their compliance program and internal controls. Up here at the top, periodic audits and reviews. So whether that's you just setting like a calendar reminder for multiple times a year or once a year, it's really up to you. Regardless, after an incident, it's likely a good idea to go back and like an incident of like non-compliance, it's good back to like go and see if you can identify any areas to correct. And so, we've seen contractors execute these requirements through like various means. There's an annual training and a refresher training to encourage and educate employees to report suspected problems. I've also seen some companies use a like ethics and compliance specific web portal on their internal systems for employees to review policies, receive training, and report suspected instances of noncompliance. Other companies, they just have a pamphlet that's available that has a hotline or some other means of communicating concerns. Sorry, I was on the wrong slide. All right, backing up. All right. All right, so it goes down here, ensuring corrective measures are promptly instituted and carried out. This gets back to a point that I think Paul and Derek made earlier, as far as if we have these policies and procedures in place, like sitting on a shelf doesn't do you any good. You need to make sure that they're actually followed. There was, late last year, I saw a DOJ settlement with a research institution that had submitted false claims. They had a policy and procedure in place that was designed to identify the non-compliance that resulted in their submitting a false claim, but they just didn't follow it, and they got whacked by DOJ. Turning this last bullet here, there are various ways to handle this. I've seen some companies that assign compliance responsibility to the General Counsel's office. Others will create a specific compliance officer, chief compliance officer, responsible for investigating reports of noncompliance. With this, you'll see folks will either put that chief compliance officer like in the same, under an organizational chart. Either they'll report to the GC, or they'll usually have like an opportunity to report like separately to the chief executive if necessary, or they'll just separate the two so that it's chief compliance officer and then general counsel, and they're separate budgets, separate resources. All right, moving on to the next slide. All right. So again, contractors are obligated to monitor and update their policies and procedures. Again, like I was saying earlier, I got mixed up in my slides. Sorry about that again. You want to set reminders. It's really up to you. Annually is probably sufficient. Disciplinary actions. Those again will depend on the nature of the misconduct, whether the individual responsible, whether they did it intentionally or whether it's unknowing, in which case, you likely just need pressure training, or whether there was just some breakdown between individuals that allowed the mistake to slip through the cracks. Reasonable efforts to not employ individuals who may have engaged in conduct. So background checks, past employer references, just looking at new candidates that you're not sure about, just make sure that you're vetting to make sure that you continue to promote culture of ethics and compliance. Concerning disclosure to agency OIG and contracting officer, we have a slide coming up, I think, later in the deck discussing best practices for this. Lastly, here's a point that Derek made, that even though these requirements don't apply to all contractors, like small businesses or for the acquisition of commercial items, it's still best practices to maintain one, even if you are exempted from it. And with that, I'm going to turn it back over to Paul. I'll let you take control of the slide deck.
Great. Thanks, Spencer. So the two most common areas where we've assisted companies, and I'm sure Derek has had this experience too, on mandatory disclosures arises with either a significant overpayment or potential violations of the Civil False Claims Act, which covers a lot of actions that a government contractor can take. As Derek alluded to earlier, there really is no guidance on what constitutes a significant overpayment. At least in my experience, it's frequently, significance is defined by the eye of the beholder. With regard to the Civil False Claims Act, there's no de minimis exception, so that if you discover that someone has caused your company to commit an invoice that was fraudulent in some way, even if it's an insignificant amount, you're probably going to have to disclose it. I mean, I had a situation about 5 years ago where an employee had been working at a government site. There was not a supervisor there. The individual could come and go as they please. And for whatever reason, the employee decided that he would really like to work a 20-hour week rather than a 40-hour week. And some of the government people noticed. They called the company and said, hey, look, individual A is not showing up for work. We checked the swipes in and out of the building, and he's only there for, 4 or 5 hours a day. But yet he was being billed as if he had worked 40 hours. Well, when you added it up, it was $2,500. I thought it was insignificant. I called the DODIG. I said, hey, look, I have this issue. Are you really going to make us disclose this? And they said, yeah, there is no de minimis exception to fraud. You guys billed us for time that wasn't work. So, you just need to be aware of that. The Civil False Claims Act had a long history. It's been around since the Civil War. It was actually promulgated back in 1863 to punish companies that were profiteering on the Union Army. There are essentially 7 situations where a company or an individual can violate the Civil False Claims Act. The one that we see most frequently is situation number 1, and this is any person who knowingly presents or causes to be presented a false or fraudulent claim for payment or approval. And this is typically going to arise in the context of an invoice. And we'll talk about some of the instances that give rise to these false invoices, but that's commonly where you see it. Situation number 2 is using a false record or statement to get payment. Situation 3 is if there's a conspiracy to commit fraud, and you'll see that in some cases. I haven't seen the government pursue that cause of action, but you do have situations where, maybe you have a subcontract administrator that has a good relationship with the subcontractor. The government's not reimbursing the subcontractor for all the money the subcontractor thinks that they're entitled to. And so the subcontract administrator and the subcontractor representative go back and backdate the period of performance so they can pick up more of their money. And I have not seen individuals prosecuted in that context, but the government's still going to consider it fraud and expect to get the money back. Situation 4 deals with property, which isn't very frequent. Situation 5, 6, and 7 are also just relatively infrequent. I mean, almost the entire situation that you're going to see commonly is situation 1. So we're going to spend a couple slides and talk about that. So for a Civil False Claims Act violation to be found under the situation number 1, you're going to have the presentation of a claim for payment to the government, and this can occur at either the prime or subcontractor level. We'll talk a little bit about that. The claim must be false or fraudulent, and the person knowingly presents the claim that is false or fraudulent. So if we look at the slide, it walks through what a claim is. And this is any request or demand, whether under a contract or otherwise, for money or property, and whether or not the United States has title to the money or property, that is presented to an officer, employee, or agent of the United States. That's going to be where you either have a grantee in the government or a prime contractor in the government, because you're going to have those direct invoices. But, some time ago, I think maybe over 10 years now, they actually modified the presentment requirement to add this second bullet, which is made to a contractor, grantee, or other recipient if the money or property is to be spent or used on the government's behalf or to advance a government program or interest, and if the United States government provides or has provided any portion of the money or property requested or demanded, or will reimburse such contractor, grantee, or other recipient for any portion of the money or property which is requested or demanded. And the reason Congress expanded this and added bullet 2, there were situations in the courts where a subcontractor had committed fraud, submitted the invoice to the prime submitted it, and then the subcontractor would take the defense to it. Well, I didn't give this to the government, it was the prime contractor that gave it. And so Congress adjusted the statute to make sure that situation was covered as well. So the next thing we're going to talk about is what constitutes knowingly, and that's defined in the Act. I mean, certainly if you have actual knowledge that the information is fraudulent, I mean, that's pretty clear. The second one is if you act in deliberate ignorance of the truth or falsity of the information. And really what this gets at is that if you know there's a problem as a company, you just can't put your head in the sand. You can't really, I mean, if any of you remember Hogan's Heroes, you can't be like Sergeant Schultz and just say, I know nothing, right? You have to do some level of due diligence. The next bullet is acts in reckless disregard of the truth or falsity of the information. You know, you have to do some level of due diligence. You have to have some level of management over your people to ensure that they are doing their job correctly and that they're billing the government appropriately. You know, to establish reckless disregard, it's more than negligence. Although I'll tell you that if you're negotiating with DOJ, they're going to apply a negligence standard. But if you get beyond DOJ or, you know, you talk to a reasonable U.S. attorney, it really is aggravated gross negligence. It's gross negligence plus. It's something more than ordinary negligence. But, you know, Dirk, I don't know what you've seen, but typically in the negotiations I've had with DOJ, they're pretty much applying a negligence standard because of the substantial penalties that are associated with a False Claims Act violation.
Yeah, I agree.
So, I mean, what you want to really take away from this slide and what's important is that unlike criminal fraud, you don't have to have specific intent to commit fraud. There's no, what we'd say in the legal thing, there's no Siena requirement. The government has to show something more than mere negligence, and that, you know, we're going to talk a little bit about some of the defenses that are available to a company that as you're developing your strategy for your mandatory disclosure, you're going to want to think about putting those in as well. But before we touch on those topics, Spencer was going to talk a little bit about the Escobar decision.
Yeah, thanks, Paul. So in 2016, the Supreme Court decided Universal Health Services v. Escobar is commonly known as the Escobar decision, and it really retooled the evaluation of viability of FCA claims. The underlying facts of the case aren't really that relevant to our discussion, but the decision, it's important for two key points. The first is here. The implied certification theory. This resolved the circuit split over whether it was a viable basis of liability. As you see, the theory treats a payment request as a claimant's implied certification compliance with all material requirements, and if the claim fails to disclose claims violation material requirement, constitutes a false or fraudulent claim. Moving on. We know, however, that the court while the court did hold that it's a viable theory, it limited it to certain circumstances. As the slide notes, theory holds when the claim makes specific representations about procured goods or services, but knowingly fails to disclose its own noncompliance, which turns its representations into half-truths. The second aspect to Escobar that's important is its retooling of the materiality requirement. Throughout the decision, the court noted and repeated the concept that the False Claims Act is not a all-purpose anti-fraud statute or a vehicle for punishing what it called garden variety breaches of contract or regulatory violations. And so doing it direct lower courts to apply a rigorous and demanding materiality standard. But first, the court rejected the First Circuit's view of materiality. I consider that to be too expansive. Specifically, as you see here in this second bullet, First Circuit's interpretation was that any statutory, regulatory, or contractual violation is material if the government would be entitled to refuse payment. Instead, as you see, the court stated the materiality of the requirement, whether it's violated, turns on the effect on the likely or actual behavior of the government. As an example of what the court would consider to be non-material noncompliance. The court noted that if the government regularly pays a particular type of claim in full and has actual knowledge that certain requirements were violated, and the government has signaled no change in its position, it's going to continue paying, that amounts to strong evidence that the requirements that were violated are not material. As I imagine some of you are wondering, what does that really mean? That seems to leave a lot of legal room in determining and, having to go through the process of settlement negotiations and ultimately litigating whether a particular requirement was material. Contractors will likely have a different understanding. Auditors will likely have a different one too. But 4 years after Escobar, we're still seeing lower courts, the district courts, appellate courts, still grappling with the contours of the materiality as materiality standard that the court provided back in 2016. With that, I think I'm turning it back over to Paul.
Yep. Thanks, Spencer. I'm not going to spend a lot of time on this slide, but you can see from the damages that are available to the government for a Civil False Claims Act violation why it's such a powerful tool for them. The first thing is that under the Civil False Claims Act, the government has the ability to recover treble damages. So if, for example, you'd falsely billed the government $100,000, their claim's going to be 3 times that. It's going to be $300,000. And then to add insult to injury, in addition to trebling the damages, they're also able to impose a fine for every fraudulent claim. So, for example, every invoice, if you submitted 12 invoices over the course of the year, the government, in addition to asking for the $300,000, would also ask for between 12 times either $11,665 and $23,331. And then, if that wasn't enough, the government also has the temerity to come in and ask for interest. So, looking at the potential liability that a company could face, companies are very quick to try to get these issues resolved as quickly as possible. Before we go to the next slide, for those of you who are seeking CLE credit, the code word for today is disclosure, which is very clever. So what we're going to do is we're going to go ahead and take the next polling question. And this polling question is, do you think your company will have to make a mandatory disclosure over the next 12 months due to any of the following circumstances? Significant overpayment, violation of the Civil False Claims Act, uncertainty regarding the use of funds received under the CARES Act, or other. So why don't we go ahead and look at that. Got a few seconds.
If people say yes, does this indicate knowledge?
Maybe it's just a hunch. Maybe it's not actual knowledge. Maybe it's just a hunch.
Right. I say number 3 might be popular.
Yeah, I think 3 is going to be popular too. I think there is so much uncertainty regarding that, and based on what we've seen in the past, that every auditor has 20/20 hindsight. That's probably where there's going to be the most significant risk, especially with the credit you're supposed to provide, and not double dip or triple dip as the government said. So let's just see what we have. Other. Okay, that's interesting. But yeah, there is a lot of uncertainty. Yeah, there is a lot of it. That's pretty significant. But CARES Act is a very, very close second, and I think that concern is, is actually is a valid concern. It's something that we all need to be concerned about as the rules continue to evolve and change. So,
Yeah.
with regard to the FCA, there are defenses to a fraud claim by the government. And some of these are going to be more important in the context of the COVID-19 pandemic than others. Typically, the three defenses that you have are government knowledge, reasonable interpretation of a rule or regulation or a contract, or reliance on expert counsel. I mean, one thing that is important that you need to be aware of, that successful performance in and of itself isn't a defense. So if you've committed, or your company or an individual working for your company has committed some level of fraud, you don't just get to walk into the Department of Justice or Main Justice, or go to the IG's office or talk to an assistant U.S. attorney and just say, you know what, did a good job, contract's completed. That's not going to cut any ice with them. So with regard to the government knowledge defense, most circuits have now held that the government's knowledge of the facts underlying an allegedly false record or statement can negate the low Siena requirement for an FCA violation, because the thinking of the courts is that it really does help distinguish in FCA cases between the submission of a false claim and the knowing submission of a false claim. So if the government is already aware of the facts, known to be aware of the underlying facts, it tends to suggest to a court that a submitted false claim was not knowingly falsely submitted. But what you're going to be required to do is the facts that you allege the government knew, you're going to have evidence to show that the government did indeed know them. And this is typically arises in the context where the government and the contractor have been working very closely together. They may be working a little bit outside the written provisions of the contract to reach a common solution to a problem. This happens very frequently during a crisis situation like Katrina, or over on the battlefield. So it is going to be important for your people to document the communications they've had with government officials if they're starting to stray a little bit outside the contract. The other thing that is critically important in the government contracting space is your employees really need to understand that there's no apparent authority with the government. The government's only bound by actual authority. I think that the government knowledge defense is going to be incredibly relevant to any CARES Act related FCA cases. I think the simplest example is that the cost allowed under Section 3610 and the DoD and GSA class deviations depend in large part on approval by the CO and clear communication with the CO. So you want to make sure that you avail yourself of that opportunity to communicate with your government counterpart and to document what occurred. And I think the more that is disclosed and documented, sort of the less likely it will be for a company, an individual, to be accused of running afoul of the False Claims Act. With regard to the reasonable interpretation defense, there is some dispute among the various courts about the extent of or potential limitation of this defense. I believe there's at least one federal circuit that has stated that even though an ambiguity in a provision may be relevant to the Siena analysis, the fact that something's ambiguous does not mean that you are going to prevail on a reasonable interpretation defense. I think that what the courts are worried about is the situation where maybe you didn't think something was ambiguous up front and you sort of knew what you're doing might have been wrong, but as soon as you got called on it, you bring in your lawyers to come up with an argument after the fact that the term is ambiguous, so how can it be fraudulent? And I think that the courts are concerned that if you manufacture this reasonable interpretation post hoc, that it's going to let some people go off unpunished. So to the extent that something is ambiguous, you should ask for clarification. If you can't get clarification, then you want to be careful and think about whether it makes sense to document, your understanding at the time, or at least talk to your counsel so that you can come to some understanding, make sure that it's documented, and try to cloak it under the attorney-client privilege. So I mean, there's certainly a risk of ambiguity in the CARES Act. I mean, it's very hastily written, and the guidance is continuing to evolve. So you do want to think through sort of what your interpretation was, and you want to try to make sure that the interpretation that you developed was either based on additional guidance from the government, or it was ambiguous and contemporaneous with the entering into the contract. I mean, the other one that defense is probably going to be beneficial under the CARES Act situation is going to be reliance on expert counsel. And again, I think this will be particularly important with regard to PPP. And so I think the bottom line is the more due diligence that a government contractor can do, the more documentation it has regarding the decision-making process and how those reflect a good faith reliance on counsel, that you may put your company in a better position to the extent that any issues that arise. Now, the other thing we're just going to touch on briefly is
Paul. I think those are all reasons why everything CARES Act related should just be really, really carefully documented. So whatever assumptions you're making, whatever costs you're collecting, whatever costs you're covering with those funds, document all your assumptions so you have a good story.
No, I think that's absolutely right. I think that transparency and documentation is going to be the key in this area. Really do. So one of the things that there also is out there in this the Civil False Claims Act arena is that there is a DOJ there's a justice manual that does give companies cooperation credit, that companies that voluntarily disclose false claims, companies that they cooperate with ongoing and government investigations, and they take the appropriate remedial measures. And the factors that the government's really going to look at is the timeliness and voluntariness of the assistance. And Derek touched on this earlier, that you really do want to get out in front of these issues and make sure that you're disclosing as much as you can, as quickly as you can. But you do want to make sure that when you make that initial disclosure that the facts are right, because you're going to get one shot at something, and if you have to go backtrack on the facts or present a different story or a different narrative, it really is going to undercut your credibility with the IG. The other thing the government's going to look at, not surprisingly, is the truthfulness, completeness, and reliability of any information or testimony provided, the nature and extent of the existence. Did you make people available? Did you provide documentation? And how useful the government found your cooperation, and then the maximum credit that you can get is shown on the slide. A lot of times, if you do cooperate, the general belief is that you're going to do no worse than double damages, but there are instances where government contractors have assisted the government and still been liable for treble damages. And there are companies that provide just incredible assistance to their government counterparts to get to the bottom of an issue, and they're still stuck with doubles. I have had a couple cases where I was able to get the penalties down to just the money that was overbilled. One of them involved a nonprofit where an individual had that worked in the facility had set up his own shadow business and then began to invoice the nonprofit for office supplies that were never delivered. And what he did was he made sure that all the invoices were below the review threshold for approval. And the problem was that these costs were put into an overhead account that was spread over a number of cost reimbursement contracts, and the individual was able to walk out with about $1 million. And I mean, that's a pretty egregious set of facts. It would have been very difficult to discover, but in that case, we were able to get the AUSA only to take allow us to repay the money that had actually been wrongfully gotten by the individual. But that was a pretty egregious set of facts. So with the next slide, I'm going to turn it back over to Derek, and we're going to talk a little bit about what your company should include in a mandatory disclosure.
Yep, thanks, Paul. So we talked about all the rules and the regs. We're going to talk a little bit about the mechanics now, and what you should include if you need to prepare your disclosure. Main thing to remember here is stick to the facts, and this gets back to what we were just saying, is especially around the CARES Act, it's really important to have good documentation. So if you need to put one of these together, you have the story already there for you, but you can document, this was the guidance at the time, this was the guidance we followed, here's how we approached what we did. But up front in your disclosure, you'll want to include relevant intro information. So information about your company, who you are, background of the business. You'll want to list the affected covered contracts or subcontracts. Number one, as a statement of fact on the situation, but also number two, to make sure you limit the scope of any investigation or findings just to those contracts. You should also list the contracting officers who have cognizance over those contracts, again, for similar reasons. And then you get to the facts. So, a good tight chronology of the events. When did you learn of the issue? How did you learn of the issue? When did you begin any internal investigation? You want a good, concise description of the issue, again, sticking to the facts. And then a description of what your investigative steps were. So who did you interview? What documentation did you review? Things of that nature. And then you also want to include descriptions of your compliance programs and how you train your people on those programs. So that's a good way to frame this particular incident as sort of an outlier. It's not a symptom of rampant fraud, waste, and abuse. The compliance program is designed to identify issues, and it succeeded in doing that. So the system works. And in a similar vein, describe the corrective actions you've taken to prevent any future issues. That could be some enhanced controls, beefed up training on certain compliance areas, HR actions that were taken, things like that. Describe any required restitution. This is sort of your opportunity to quantify any restitution as you see it, rather than waiting for the government to unilaterally tell you what it is. So demonstrate that it's reasonable. And then include a conclusion to tie a nice bow on the matter. And again, here's another opportunity to tout that your compliance programs worked. They did what they were designed to do, assuming that's the case, of course. And I think that takes us to another polling question.
Yeah, I mean, a couple points that I think are important about, what to include in this is that, I agree with you. You really do want to stick to the facts. I try not to characterize the facts, and sort of, if I can get away with characterizing something as not significant overpayment, that's going to be my first line of attack. My second line of attack typically is, if there is some money in play, let's try to treat it as a garden variety contract administration issue. And then the last thing I think you do is, if it's an individual that has perpetrated the fraud, put the company in a difficult position, I pull out my "I'm with stupid" t-shirt, which points at this individual, and then I go into great detail about, what we have done as a company to train our individuals to act in an ethical manner. You know, maybe you'll go through their onboarding procedures, go through the various documents that show that they've agreed to abide by the code of conduct, that they've agreed to promptly report fraud, that they've had their regular updates, so that, you know, you're trying to portray the individual as a bad actor that, despite your company's best efforts, you know, wouldn't follow the principles and the tone that had been established by the company. I think the other thing you need to be really mindful of too is, you know, you're going to go, like if you go to the DoDIG and it's a Navy contract or an Army contract, these things do get forwarded to the suspension and debarment officials for the various departments, and you really should be familiar with the specific. You need to know who the contract is with, and you need to have some familiarity with the suspension and debarment official, because there are suspension and debarment officials that if you do a mandatory disclosure and it doesn't look like, you know, you've done enough training or taken the appropriate steps to establish a culture of compliance, you're going to get a show cause notice from the SDO asking why you shouldn't be suspended or debarred. And undertaking that effort and responding to that letter is a lot more labor intensive and expensive than if you would just kind of outline what you had done all along in the first instance to try to ensure that your employees are, you know, going to act in an appropriate manner. With that, why don't we go ahead and go to the next polling question, which is, over the last 2 years, my company has made the following number of mandatory disclosures: none, 1 to 5, greater than 5. I'm going to say I think the answer is the vast majority is going to be none. What do you guys think?
I'd agree with that.
Yeah, especially when we had, like, was it 60% that said they hadn't made a mandatory disclosure? From our earlier polling question? Yeah.
Mm-hmm.
Yeah, it's not that none.
Which is good. I mean, I think it means that, you know, companies take this seriously, they understand the risk, and that, you know, they're doing a good job training their employees, which is good, which is what, you know, what the government wanted. So let's see. Yep, there it is. Wow. 79%. Pretty good. It's really good, actually. All right, so why don't we go ahead and say. Oh,
this is me again.
Yeah, sorry about that.
No, that's okay. Yeah. I mean, some of these are repeats of what we were just talking about on the previous slide. So again, you know, stick to the facts, as Paul says. Don't characterize, other than to characterize things as outliers, not as systemic. Talk about your compliance programs again. Talk about your training. Talk about your, you know, training of your employees, your culture of compliance. Consider the agency you're dealing with, as Paul said. And then, you know, the bottom bullet there is really important. So if you have any holes in your current compliance program, fix them, retrain your people, get everything back on an even footing. And I think it's back to you, Paul. Oops, skip one.
We might have skipped one. Oh, sorry about that. There we go. So just the next couple of slides, we're just going to talk, and, you know, Eric and Spencer have done a bunch of these as well, but, you know, this is sort of where these areas commonly arise. Incorrect recording, charging a time is pretty common. You typically see people overstating their time where they're not in a supervised environment, and given that everybody's working remotely now, this probably presents, you know, some increased risk. But a lot of times, you know, you have employees located at a government site, they'll come and go as they please, and, you know, you'll get an email from somebody in the government that it doesn't appear that the individuals at work. LCAT or qualification issues where your employees are required to have a certain certification or a certain number of years experience in order to be in a specific labor category. A person leaves, you plug in another individual in that category that doesn't have the requisite quals. The government's going to take a look at that. Product substitution, incorrect certifications are significant, both ones that are required and implied. Like I mentioned with my story, I have seen, backdating a documentation to extend a period of performance. I hear some of these other ones, like you're just surprised that they occur because you would think that everybody knows that they're wrong. But, I had to do a mandatory disclosure where one of our clients had, they were out of their labor money, but they had a chunk of about $500,000 in ODCs that weren't going to be spent. And so the COTAR thought it'd be a great idea if we hired more people and then just billed them through the ODCs. Well, that was not acceptable to the government. We had to make a mandatory disclosure, but that really gets to 2 points. Make sure you're using the money appropriately for what it's authorized to be used for, and also make sure the person has authority to order you what they're going to do. I mean, certainly, you're all familiar with a contracting officer's technical representative. A COTAR doesn't have the same authority on a contract that the contracting officer would have. And even if the contracting officer had ordered that, a contracting officer, can't order people to or can't approve fraud. Testing is a big issue. We've done a lot of disclosures on that. Falsifying that things pass the test or, pass some gate. Labor mischarging. I think the worst case I saw here was, you walk into this conference room and there were a wall of open contracts. And irrespective of what was going to occur that day in the company, people got assigned a contract to work on. And lo and behold, most of the people that got put on a cost reimbursement contract were working on a firm fixed price contract that was underwater. So if that happens, that's bad. You're going to have to disclose that.
You see that in a lot of different flavors. You see that in a lot of different flavors too, Paul, where program managers may think they're doing the right thing because they're managing their budget for whatever reason, but shifting labor between CLINs on a contract, as you say, between contract types, moving stuff to the cost reimbursable and off of fixed price, moving stuff between contracts. A lot of different flavors, and that gets back to what I was talking about earlier in the presentation is, as soon as they nail you for this, the next thing they're going to do is come after your accounting system because you don't have proper controls around your labor charging. So you're going to get whacked here, and then you're going to get your accounting system deemed inadequate as well.
Yeah, we just got a question. What's the LCAT? It just is a labor category. It's just all caps LCAT. It's labor category. So I apologize for using that acronym. But I mean, these are probably the most common areas you see things though, right? Or on time charging, cost issues.
Yep.
Don't you think?
Yeah, I agree.
I think the last thing we're going to do, and if we have some time, we'll take some questions, are talk about some practical tips. And Derek is going to just walk us through this.
I'll walk you through these. Guys, chime in as you see fit. So some practical tips for maintaining compliance. These can be really specific to your business and what your compliance requirements are. Not all compliance programs are created equally. So they're really dependent on your contracting portfolio to a certain extent. So some contractors have contracts subject to TINA, some don't. Some are subject to cost accounting standards, some aren't. Some primarily operate in a commercial contracting environment. So, while basic ethics is sort of a constant, that's the bedrock, specific compliance requirements aren't. So you should consider consider if your people need training on proposal preparation, for example, if you're certifying your cost and pricing data under TINA. Cost allowability training is important. Timekeeping, as we said, is a huge deal. cost accounting standards, if those things apply to you, specific invoicing instructions. So these are all areas that can lead to compliance escapes, where you need to have policies and procedures as well as good training programs in place. And then a few more here. Big one is shown at the top. So promote that culture of compliance and be able to back it up, again, with training, with acknowledgments of your code of conduct. Have those good compliance programs we talked about in place, be able to produce records of your employee training. Make sure your employees know where potential trip hazards are in your business so they can err on the side of caution. And to that end, make sure employees have a basic understanding of your contract T's and C's so they know where those trip hazards come from. And then if you find yourself in a disclosure or potential disclosure situation, make sure you have a point of contact at your business and channel all your communication to the government agency through that person. So it's really important to stay on message. So a single POC can be important. Finally, the bottom bullet there, if you don't already do this, consider exit interviews with your former employees. They can give you some good feedback on the culture. They can help identify risk areas. Sometimes you need to take that with a grain of salt, of course, but it can provide some useful information on your business. So some of these things you really need to tailor to your specific business and your compliance requirements.
Yeah, and I think that it's a good point. I think the other thing I've seen that I thought was helpful is when people were leaving the employment of a company, they would have to certify, or they would certify that they were unaware of any fraud that had been committed while they worked there. And I think that sort of, documentation is good because it does put your company in a position that, you can show the government, well, this is the information we had. We were unaware of this. To the extent that problems do arise, if you can show how you've resolved them. I mean, certainly you don't want to be impose, too much discipline on your employees, but every now and then, you do have to show that you take these issues seriously and that, people are admonished or fired or punished in some way when they don't follow the rules that you've established for your company. So we're going to do one more polling question, and then we'll take some questions that have been submitted, and then we'll wrap this up in about 9 minutes. So let's go to the last polling question. And the last polling question is, please identify any topics you'd like to be the subject of future webinars. I'll give everybody like 10 seconds to do that, and then we'll just go ahead and wrap up with some of the final questions. Okay. So we've had a number of questions that have come in, and we'll try to answer those. To the extent we're not able to answer them in the time we have remaining, the three of us will put our heads together and give you a written response. I think it's important to make sure that you get your questions answered. So the first question we have is, if the prime neglects to include a FAR 52203 type clause in a subcontract under a covered government contract, will the Christian doctrine read such a clause into the subcontract? And while we were on the phone, Spencer was kind enough to do some research, and he could not find an instance where the mandatory disclosure provision had been incorporated into a contract by a board or court. But that doesn't mean that, that it couldn't be. It just means that the question hasn't been decided yet. I think with regard to, my understanding has been, and I haven't researched it in a while, and I know there may be some people that hold a different view, that the Christian doctrine doesn't typically apply to subcontracts. It's a doctrine that applies to a prime contractor's contract with the federal government. Yeah, we got a question that, while the emphasis of the presentation relates to FAR compliance, can you make some brief comments regarding compliance for financial assistance agreements, grants, and cooperative agreements under 2 CFR Part 200? Candidly, I don't do any grants work, so I'm not able to comment on that. Derek or Spencer, I don't know if either one of you have done grants work where you could talk a little bit about the interrelationship of the Civil False Claims Act and grants.
I am not with the grants portion of our practice, but I can find people who are if Spencer can't answer that.
Yeah, I've done some work with grants, so I can give some kind of like high level, mostly just like examples of what I've seen. So I think someone had also asked about does the False Claims Act apply to grants and cooperative agreements, even though grants and cooperative agreements are governed by the uniform guidance and not by the FAR? The answer is yes. False Claims Act applies. It's not by the terms of the FAR that it applies, but it's just the statute applies to anyone who makes a false claim to the government. That said, like what I've seen both in practice and also in just reviewing DOJ settlements is part of it. I mean, most recently, the interest the federal government has expressed is looking at funding agreements, like other funding agreements. There's been a couple of research institutions that have received foreign funds, primarily from China. And if auditors come in and identify that there's overlapping research funds, so that a Chinese grant is funding a project that's also being funded by U.S. federal dollars, if that's not disclosed, then that's a violation of usually of the terms of any research grant. So you'll see False Claims Act settlements related to that. Other areas, as far as not in the context of FCA compliance. I mean, the biggest areas I've seen with compliance under grants and cooperative agreements are, monitoring subrecipients and maintaining. If you do procurements with federal grants, following the uniform guidance requirements on that. But just at a high level, that's kind of my 2 cents on compliance issues for grants.
Yeah, I mean, I think I haven't worked a lot in that area, but I think what I've seen is that a lot of the entities that receive a grant from the government, because a lot of them are nonprofits, they don't necessarily have as fulsome a compliance program as some of the mainline government contractors do. And so I'm not sure that it's not wanting to do the right thing. I'm just not sure it's having the proper infrastructure in place that enables them to sort of turn the square corners that we all need to turn when we deal with the federal government. But yeah, and I think that actually, given the money that gets pushed out the door, you may see a greater emphasis on U.S. attorneys and people at DOJ taking a look at grant recipients to see where a lot of the funds are going. Let's go to the next question. So one of the questions we had is, don't you think one of the major problems was that the law on what to report was unclear and the DOJ early on refused to clear it up or adopt a de minimis rule? Yeah, I mean, I tend to agree with that. I mean, you would think there were a lot of comments in the Federal Register back then that focused on, clarifying, the time, when you had to disclose things, what was a significant overpayment, and, I don't know what the government's thinking on with regard to why you wouldn't want to define that and give the government and give contractors a clearer roadmap. So I'm not sure. Do you, Derek or Spencer, have any thoughts on that?
No, I agree. I was in industry at the time when the rule came out, and every industry association meeting I attended, every contractor had a different approach at how they were tackling this. So there was, yeah, clear guidance would have been nice. A de minimis rule would have been super helpful, because that would have got rid of a lot of that nickel and dime labor reporting that people were doing.
Yeah, and I agree. And I mean, at least early when the rule came out, there were a lot of letters that our clients wrote or that we wrote for them that, you sort of write, I don't know if this is an issue or not, but out of an abundance of caution, I'm just going to tell you about it and let me know. And a lot of times, when you disclose these minor issues, they go over to the IG and you never hear from them again. You don't know if it's closed out. You have no idea what happens. But, I've had some that were 10, 15, 20,000, mischarging, people not showing up to work and billing the government for it under labor contracts. And lo and behold, we do it. We try to portray the individual as a bad actor, and then we still get a letter from the suspension and debarment official as to why we didn't have better control over our employees. I think it's probably, part of it's just to maximize, I think, the government's flexibility, but I also think that if you don't have firm guardrails, that people probably are going to over-disclose. So maybe the goal was to keep people motivated to keep the information coming in so that the government could call balls and strikes on it. I mean, because it used to be a mandatory disclosure provision previously. They didn't think people were abiding by that, so they made it mandatory. And so maybe they're trying to, by giving less guidance, force people to look at this more critically and make a more careful consideration about whether to undertake a disclosure or not. Well,
and there were some unintended consequences to that too, Paul. When an abundance of labor charging issues, TCAA gets wind of that, and then they call into question your labor collection processes. And not to beat a dead horse, but that leads back to your accounting system again. So some unintended consequences there.
Yeah, and I'm not sure the government always thinks through that. There are a few questions we'll have to get to via email. I apologize. It is 2:30. I appreciate all of you staying on the call. I hope that you all are safe and well, and we'll look forward to you attending one of our future webinars. Thank you.